Welcome everyone to Immigration Talk Show. In our last chat, we delved into the nuances of changing jobs while holding an H-1B visa. And today, let's embark on a journey that many of you are curious about. That is transitioning from an H-1B visa to obtaining a US green card or permanent residency. Think of this process as a series of steps, each bringing you closer to your goal. Now let's walk through them together. Number 1, employer sponsorship. So friends, the first step towards obtaining a green card is securing an employer who is willing to sponsor your application. Well, this sponsorship is typically under employment-based categories such as EB2 or EB3. EB2 is for professionals with advanced degrees and EB3 is for skilled workers. It's essential that the job position aligns with the criteria of the chosen employment-based category. Next up, PERM labor certification. So once you have employer sponsorship, the next step is obtaining a permanent labor certification that is also known as PERM from the US Department of Labor, also known as DOL. Well, this certification ensures that hiring you will not adversely affect the wages and also the working condition of US workers, and also that there are no qualified US workers available for the position. The PERM process involves number 1, job advertisement and recruitment. So the employer must conduct a recruitment process, including advertising the position in various forums to test the US labor market, then also filing ETA Form 9089. After completing recruitment, the employer files ETA Form 9089 with the DOL. And if we talk about timeline, then the PERM process can take several months depending on factors like recruitment duration and also DOL processing times. Next up, Immigrant Petition Form I-140. So after obtaining PERM certification, friends, your employer files Form I-140. Immigrant Petition for alien worker with US citizenship and immigration services, also USCIS. This petition establishes your eligibility for the employment-based green card category. And if we talk about the timeline, then USCIS processing for Form I-140 typically takes several months, while employees may opt for premium processing, which expedites the decision to within 14 calendar days for an additional fee. Moving ahead with priority date and visa bulletin. So the filing date of the PERM application becomes your priority date. You must monitor the US Department of State's visa bulletin to determine when your priority date becomes current, that indicating visa availability for your category and also country of birth. Well, due to annual visa caps and high demand, especially for applicants from countries like India and China, waiting times can extend several years too. Next up, adjustment of status or consular processing. So when your priority date is current, you can proceed with one of the following. Number 1, adjustment of status, Form I-485. If you are in the US, you can file Form I-485 to adjust your status to permanent resident. Concurrent filing of Form I-485 with Form I-140 is also possible if visa number is immediately available. Next, consular processing. If you are outside the US, then you will undergo consular processing at a US embassy or consulate in your home country. And the adjustment of status process can also take several months to over a year depending on USCIS processing times. Moving ahead with receiving the green card. Well, upon approval of your adjustment of status or immigrant visa application, you will receive your green card, granting you permanent residency in the US. Well, friends, the total time to transition from an H-1B visa to green card status varies based on factors such as country of birth, specific employment-based category, and individual case circumstances. As of 2025, the process can range from approximately 2.3 to 5.1 years, with potential for longer durations for applicants from countries with high demand. So friends, that's all for today, but before leaving, let's have a quick recap. Firstly, maintain H-1B status. It's crucial to maintain valid H-1B status throughout the green card process to ensure continuous work authorization and lawful presence in the US. Next is employer changes. Well, changing employers during the process can complicate your application. So it's advisable to consult with an immigration attorney before making such changes. Next, dependents. Spouses and unmarried children under 21 can also apply for green cards as dependents. Well, navigating the green card process requires careful planning and adherence to timelines. Consulting with an experienced immigration attorney can actually provide personalized guidance tailored to your specific situation. So thank you so much everyone for joining us in this episode. If you found this information helpful, then please like, share and subscribe for more insights on Immigration Talk Show. And if you have any question or topics you would like us to cover, then please leave them in the comments below. Until next time, friends, good luck, take care and keep watching Immigration Talk Show.